Hey everybody, Jay here. We're going to do a video review of Chapter 7. Have a request to do some virtual class for someone who can't make it, and I just thought this would be fair to make it available to everyone as well for those test reviews. So anyway, Chapter 7, the international legal environment is what we're going to talk about. Let's go ahead and dive in. Okay, so here we are getting started, and the first thing we need to talk about is President Bill Clinton. Now, this is back in 1996. And he signed this act called the Helms-Barton Act. And basically what that did is it made it so that the U.S. would bar any U.S. company, but get this, any foreign subsidiary of a U.S. company to be able to trade with Cuba. And that was largely seen by the world as kind of the U.S., kind of being big brother, telling the world what they can and can't do. And obviously other countries don't want to lose their sovereignty. They don't want other governments telling them what they can and can't do. And so there's a great example in the textbook called the Cuban pajamas. So in 1996, Bill Clinton signed that deal. And in 1997, the Cuban pajamas issue happened. And so Walmart Canada was all about some Cuban pajamas. Like they loved them. They sold well. But Walmart headquarters in USA got wind of the fact that Walmart Canada was putting these Cuban pajamas on their shelves, and they said, no, pull it. Canada freaks out, not really happy about the fact that U.S. is telling them they can't have their Cuban pajamas, and basically telling them that you can't be putting U.S. law into our country. Basically Walmart headquarters had a big decision because they were going to be faced with fines by fines by the Canadian government or fines by the U.S. government, regardless of which way they went. So there's a question here, what would you do? If you were in the headquarters of Walmart, what do you do? Maybe a chance to pause the video and give it some thought. So let's talk about international commerce law, and let's be aware that it gets complicated really quickly. So you've got four kinds of legal systems in the world. You have common law, civil or code law, Islamic law, and then what we're calling the commercial legal system in Marxist and socialist economies. So common law is what we have. It comes from England, and it's where basically everything is set on some legal precedent. Then you have civil or code law, and that's where you have some kind of basic law and then a catch-all phrase that says you can't do this or this affects all people in this situation. Islamic law is totally different. It's based on the Quran, so it's a religious legal system, and you're going to find that in your Islamic countries, Pakistan, Iran, Saudi Arabia, so on. And then, of course, the Marxist socialist countries. We've seen China get really big in commerce and dealing with foreign governments for entrepreneurship and things like that, capitalism. And so anyway, they have to have a way that aligns with their communist philosophy, communist system of government, with some sort of a commercial law system. And so that's what we're talking about there. Now, go ahead and let you guys zoom in a little bit more on this map. So this is breaking down the world by its legal systems. And you notice I have three that I've marked here. You have common law, which again is us leaning on legal precedent. You have code law, which is basically a series of laws that are written in advance and with catch-all phrases that address everyone in situations that might be needed, and Islamic law based on the Quran. So we'll dig in a bit more in common law. Again, it's tradition, past practice, legal precedents, things like that. And then based on that, you're going to find interpretations. Kind of a classic idea is some lawyer thinking, okay, well, based upon this ruling of some judge a long time ago, and meanwhile in the background he's going through all these legal books trying to find that ruling by some judge a long time ago. It's a lot of work to try to figure out which law can be used as precedent since it's not an overarching code. And then you've got this issue with legal interpretations, right? The fact that one judge might see it one way and another judge might see it another. In fact, there's a class reading here. You can go into the PowerPoints and find the link. But basically, it's a court case about the Miranda rights, and it goes all the way to the Supreme Court. And it's interesting to note that the different Supreme Court judges have different interpretations of the law. That's significant. That even in the same court, Supreme Court, these justices have different opinions. And you'll see that if you dive into Supreme Court rulings in the past, that often they do not see it eye to eye. Now, civil or code law, that's, again, the all-inclusive system. Like, everything's written out, and there's this catch-all provision that's going to be able to apply it in most situations. Two key differences. We'll talk about intellectual law, and then we're going to talk about contract law. So intellectual law, when you talk about common law, or the way we practice law in the U.S., ownership is established by use, right? The fact that, like, I've used this for 10 years, everyone knows it's mine, we assume that we have some obvious precedent there. Like, that's ours. That is our trademark. That's our brand. If Nike swoosh, was suddenly operating in a new country, we would imagine that everyone would understand that the Nike swoosh is the Nike swoosh. Whereas in code law, those countries' ownership is determined by registration. So you could have a Nike swoosh, and someone in that new country creates the patent for it, and there you go. Nike no longer owns the swoosh in that country. In fact, they never did, because they never had the registration. Now, contracts are another head scratcher for us. Common law, you've got act of God, meaning nature, right? An act of nature, a hurricane comes in, a tornado, a flood, things of that nature. But code law is very different, because they've also introduced the idea of an unexpected act of a third party. A labor strike or a riot would never be considered an act of God in common law, but in code law it most certainly is. And we see this playing out even right now. You've got, the conflict in Ukraine, and German law is calling force majeure, unforeseeable circumstances that prevent someone from fulfilling the contract. And they're saying that, these contracts, cannot be performed. Non-performance of contracts, right, based on German law, which is code law. So we're seeing this war being considered an act of God, and therefore contracts cannot be honored due to this. Now, here's an example. Give yourself some time to think about it, but you've got a U.S. company and a Japanese company, okay? And the U.S. company is common law, the Japanese company is code law, and the Japanese company agrees to sell to the U.S. company a certain amount of this fabric, right? Like the fabric in this background. Okay, and while it's being held there, a sprinkler system freezes, and the pipe explodes, and the material is damaged. Now, what happens? In common law, right, this would not be considered an act of God, and the U.S. company would be owed the product at the agreed price. But in code law, Japan would say that this is an act of God. It was out of their hands. It was, there's nothing they could have done to, to know this was going to happen or to prevent it, and therefore the contract is null and void. So, what's the legal outcome here, right? What happens? So this is an idea of a problem that you might face when you think about common law and code law and how they work together in interactions. Because when you deal with global marketing, you're going to see this, right? Now, primary basis for commercial law. So in common law, is the primary basis for commercial law, but there's also this thing called the Uniform Commercial Code, and it's like the codification of commercial law. So even in the U.S., where we practice common law, there is a bit of codification in commercial law known as Uniform Commercial Code. So here's some information about it. If you want to dig in a little bit deeper to understand what UCC is, this is looking at it, in different ways, and dive in, look at this more. We're not going to cover this very much in our chapter, but I did want to bring it up to you and let you know it exists. Let's dive into Islamic law. So based on the interpretation of the Quran, right? And so there's some things you have to think of when you think about Islamic law, right? Because it's coming from a religious text, right? That isn't the root of what Islamic law is. There's this emphasis on the ethical, the moral, the social. There's an idea of equity and fairness and what's for the good of society. And we see this play out when it comes to property rights, economic decisions, types of economic freedom. And of course, it's also vulnerable to interpretations. Obviously, the way I think about the Quran, the way you think about the Quran are likely going to be different in some way or another, And if our legal system is based on it, that could open up some interesting discussions, right? So here's some interesting prohibitions. Now, this is for Islamic finance, but it's based on Islamic law, so I definitely think it's interesting. So paying or charging interest, can't do it. Can't pay or charge interest. You shouldn't engage in things that are uncertain or that are with risk. Investing in businesses involved in forbidden activities. Think about pork or gambling, and speculation. Right, these sort of things would be forbidden. And so this screen dives into those three a little bit more, and then the next screen dives into the fourth one. But the one that's really a head scratcher for me when I first came across Islamic law was the fact that you can't do interest payments. Because imagine you're buying a home and you don't have the money up front. So how do you do it, right? How do you pay for this home without paying interest and still have someone who wants to sell it to you, right? If I own a home and you want to buy it and you can't pay me for it and I can't charge you interest, what's my incentive to want to sell you this home? I think that's an interesting conundrum, one to chew on it, and we'll get into some options there in a minute. Obviously, can't invest in prohibited activities, selling of pork or alcohol, things like that. And speculation, right? Basically, if institutions can't be involved in contract where the ownership of a good depends on an uncertain event in the future. And then uncertainty and risk. Again, we see this in regards to signing contracts with excessive risk and uncertainty. One thing that was really interesting about this is profit loss sharing, which I would love a student to discuss this if they're interested in Sharia law. But basically saying parties entering into a contract in Islamic finance share the profit and loss and risk associated with the transaction. No one can benefit from the transaction more than the other party. That's fascinating and really interesting. There's a lot of stuff here that I think could be really examined more closely. I'd encourage any student that wants to do something like this for extra credit, definitely jump into it, right? But if you think of these, what challenges present themselves to you, right? Definitely something I'd pause the video and give it some thought. That'll definitely help you digest these ideas a little bit more. Now, this is a group discussion that we did in class. You want to buy a home, you cannot afford to pay it in cash. How can you buy and avoid violating interest restrictions in Islamic law, right? And this was just a chance for us to think about different things. I remember Caleb in the class was really shocked by this one. He was really curious as to how you would do this, and other people came up with some ideas. We'll jump into the way it's actually done here. So here you would have two people. One person buys a home, buys the majority of the home, and the other person maybe pays what they really want. And that person pays what they're able to, sorry. So the person who pays what they're able to, maybe that's the person that really wants to live in this house. And so what they would then do is make monthly payments to the main investor. And I would say they would add additional payments onto it. So it's not interest, it's a margin, right? So it's an interesting wiggle room there, is to be able to add margins so that you're basically increasing the value of the thing you're selling. So yeah, and this just breaks down a little bit more. The financier buys up front, margins mutually agreed upon, and then that total price is increased, right, and sold via repayments. So, and this was a thing where we wanted individual thought in the class to see who volunteered. If Islamic law is based on the Quran, would Islamic law be the same in all regions? Right? I'd love for you to pause the video, think about that, think about the way Islam or the Quran is interpreted in different places in the world, and see what you think of it. Now, one very clear visual representation of this is the way they perceive the appropriate dress for women. So this was really interesting. We can see a spectrum, and we see that in places like Lebanon, you have a higher percentage supporting to the far right, whereas in countries like countries like Saudi Arabia, you see more to the left. So definitely we see different interpretations of the Quran, what is appropriate and what is not. That becomes fascinating, because then we can only assume that other things within the Quran would have similar differences in interpretation, right? So it's a neat thing to think about. All right, let's start with Chinese law and the new communism, right? So the fourth constitution in China, right? So they've had their fair share, okay? is modeled after 1938 Constitution of Soviet Union, so it seems ancient, but it's not. Okay, it actually liberalizes economic policies, and then this last part is what really is wild. And this was done in 1982 for anyone who was curious. So they're actually encouraging extensive foreign participation in all aspects of the economy. Wow, not something that was probably done very easily. And just to give you an idea of how that affected things, in prior to 1982, there were only like 4,800 lawyers that were in China, whereas by 2019, you got 473,000 lawyers in China. Clearly, this new constitution really changed things and the need for lawyers to do that. 300 commercial laws are actually in place. Now, there has been some concern that the laws in China are maybe not as clear. They lack some of those catch-all phrases that are in code law. So that there is a lot of room to grow, a lot of room to improve. And so, just as an international marketer, you're going to have to think about these different legal systems, especially if you're operating, right? If you're a business person operating out of the U.S. in partnership with Saudi Arabia, you've got common law and Sharia law. If you're maybe working with a distributor or vendor in Japan, and now you've had 3 different legal systems, a lot to digest there to get behind, right? Now, and the other thing is you have to determine whose legal system has jurisdiction over commercial disputes, because no such body exists, right? We don't know, whose legal system has jurisdiction over commercial disputes. Sorry, I just wanted to grab a little sip of water there. And if you're thinking, oh, maybe it's this International Court of Justice, you'd be incorrect. They don't do commercial law, right? This is basically one government having an issue with another government, not the kind of thing with maybe Amazon having issue with a Malaysian supplier. And with legal disputes, you have about 3 different kinds that you need to break down. You've got the disputes between governments, right? Disputes between companies, and disputes between a government and a company, right? And those 3 different kinds. And then basically you've got to think about how would the jurisdiction for those 3 different kinds of legal disputes be resolved. You'd have to think, okay, is there a jurisdictional clause in the contract? Does the contract say where things will be taken care of? Where was the contract entered into? Did we sign the contract in your country or mine? And basis of, where was the provision of the contract actually performed? Was that done over there, over here, somewhere in between? A lot gets broken down. So here's a perfect example of a jurisdiction clause. So the parties hereby agree that the agreement is made in Oregon, USA, and that any question regarding this agreement shall be governed by the law of the state of Oregon. Right? Now, imagine this situation. So if an injured party from Oregon brings suit in courts of Mexico against a Mexican over a contract that included the previous clause, what's likely to happen? Now, this was a head scratcher for the class. No one really got it right. One person said that they would then have to take that person, bring them back to Oregon in order to go through the suit. Other people said that, well, because the court's in Mexico and you're dealing with a Mexican, Mexican law would take precedent, and so anyways, it was interesting. And one thing you got to realize is it's actually likely the trial could occur in Mexico on the basis of Oregon law. Like, that's the power of a jurisdiction clause, and how mind-blowing is that to think that that might actually happen. It's pretty wild. And when you talk about a dispute on an international level, taking someone to court is certainly not the first thing you want to do. We obviously want an informal solution to be made that's better for all parties. Absolutely. Less expensive, less time absorbed, and you can get back to doing business quicker. So definitely informal is better, but there are varying degrees of how this is done. So here it is, you're engaged in a commercial transaction, but the foreign buyer refuses to pay. And we got into groups and discussed this, and the large consensus was, I'd sue them, right? That's what I do. And I want to introduce some other prospects, right? the first thing you would really want to do is review the contract. I mean, there's no doubt about that. You'd want to review the contract, go back over it, and determine if there's anything written here that can help you figure out how to move forward, right? And obviously, we'd want to try to resolve it informally, right? We want to make sure that we've given every effort to see if we can solve this just together, without bringing in any officials. Now, if you can't find an informal resolution, what's your next step? Well, conciliation, right? Or mediation is what a lot of people call it. And this is actually where this third person comes in and they try to work on finding a solution for the two parties, but it's a non-binding agreement. So it allows kind of people to hash out their ideas, their thoughts, their grievances, frustrations, and then eventually get to something. But it is done completely private and it's confidential. In fact, if there's litigation or arbitration, which are the two other ways that we'll discuss, you can't bring this into as evidence. So that's really interesting. I like that part a lot. And obviously they're finding this to be less threatening. Now in China, interestingly, this is really popular. And definitely, we talked about Guangxi in the class. Definitely better for Guangxi for the two parties to be able to maintain their relationship, find a solution, right? But again, it's not legally binding, this conciliation. So if you can't resolve through conciliation, the next step would be arbitration. And you got the gavel in the picture here, right? So you kind of get a sense, okay, there's more teeth in this. There's more of a legal aspect to it, I guess. And that's completely right. So this procedure is an alternative to litigation, right? And in which basically parties that have a dispute, they select some third party, an official party, right, an arbitration organization that's going to act as a referee. And they make a judgment, and the parties agree to honor that judgment. Now, arbitration is usually done under a formal arbitration group, and there's a number of them. They're mentioned in the book. There's an established process, right? First, conciliation is attempted, right? We talked about that just a minute ago. The plaintiff and the defendant each select one person to defend them, and then the organization chooses the third person, right? And then basically, obviously, great advice here is put an arbitration clause in the contract. You want to know that there's something in the contract that's going to say that if we have a problem, we're going to move towards arbitration if conciliation is not successful. Because I guarantee you, when you have people butting heads, it's a lot harder to work out details like this than it is when everyone's super excited about getting the contract signed and moving forward with it. All right, now this is a video that's going to show us a bit of arbitration. I think what we're going to do is I'm going to hold off on this because the video is probably getting quite a bit long here. So we'll wrap this up. So if you enjoyed the video, that's great. If you're in the class, if you're not in the class, what are you doing watching this video? No, I'm just joking. But I had a request to make these available virtually for a student who wasn't able to join us. Out of complete respect for that student, I want to be able to do this. And we'll put up another video starting right off with the video. All right, cheers, everybody.